Yes. Is where Mr. Justice Mostyn starts his analysis of overseas ceremonies dealing with the Law Commission. I can go pretty quickly through this. You'll see that he has outlined at 64 the relevant statutory provision, section 14, subparagraph 1 of the NCA, then cites the well-known principle in Sotomayor about it's the law of a country where a marriage is solemnized must alone decide all questions relating to the validity of the ceremony by which the marriage is alleged to have been constituted. That's Mr. Justice Mostyn's emphasis, and I would also emphasize alone. Then you've been taken to Berthiaume and Dastius, a striking consequence of an invalid marriage. Paragraph 67. Mr. Justice Mostyn, in my submission, was being accurate when he commented that all questions relating to the validity of the ceremony have not been finally determined, certainly not in recent times in this court. And there has been a debate, which we've been having in this appeal, as to the width of that principle. He then refers to Mr. Justice Coleridge's judgment in the hot air balloon case, Burns and Burns. And the final sentence of that citation, the point is that it is invalid by local rules and by English law having determined that it is invalid, a decree of nullity is available, not must follow. I accept he doesn't go on to say not binding either, which is, I think, where Mr. Justice Mostyn might end up. And then paragraph 68 is where Mr. Justice Mostyn starts sort of analysing what the test might be. Undoubtedly true once the foreign law has determined the question of validity, and once that determination has been recognised by this court, then the actual relief that is awarded, if any, is the domestic remedy of the grant or refusal of a nullity order. And that's the point I was making before the adjournment. That seems to me to state the obvious, says Mr. Justice Mostyn. However, this principle does not tell us precisely what the remit of the foreign law determination is. And that's his big, if I may respectfully say so, contribution to this debate, is introducing this concept that he does later in that paragraph of ramifications. So, in my judgment, the binding determination by the foreign law does not necessarily come to a halt at the question of the validity of the ceremony. If the foreign law not only determines the question of validity, but also determines the ramifications of invalidity, if found, then in my judgment, that corollary should also be binding, provided that it is not necessary, or it is not obviously contrary to justice. It seems that that is simply an application of the existing English legal position set out in the preceding paragraphs, particularly section 14.1 of the Matrimonial Causes Act and the three citations that follow.
Well, can you just help me, Mr. Haynes, with that proviso, provided it is not obviously contrary to justice? That presumably means contrary to the view of justice taken by the courts of England and Wales.
I think that must be right.
I mean, is it unkind to say that that sounds a bit like the foreign law is binding unless we disagree with it, in which case it's not binding?
Well, I think there needs, I mean, he talks in terms of presumption of being binding. Yeah. It's presumptively so. Both Mr. Justice Coleridge and Mr. Justice Bowley disagreed with the position under foreign law. Yeah. I am able, in my submission, to explain those decisions using that prism. They to refuse in the one case or to grant in the other a decree of nullity would have been not obvious but contrary to justice, and one can see on the facts of those cases, particularly the hot air balloon case, if I may say so, which Mr. Justice Coleridge's case of Burns, but it would have been unjust. One can make the point that it would have been unjust on my lord's former client in the South African case too. It could be, I suppose, seen that the English court decides its own notions of justice, bearing in mind the remedies, or to be more precise, the actual remedy available in this jurisdiction, but also the remedy sought. I mean, plainly, each case will turn on its own facts and circumstances, as will where the balance of justice will fall in any given case. But in my submission, there's no reason why questions of justice and fairness shouldn't enter the debate at some level. Mr. Justice Mostyn goes on to give an example of where the parties have disregarded the marriage laws of the other country when devising their marriage ceremony, to such an extent that the court, that's the foreign court, would, if the matter came before it, treat the ceremony as being entirely non-existent, giving rise to no entitlement to make a claim in court for anything. Can I just pause there? Of course, that's what this court ultimately determined in the case of Akdar, where the marriage in that question, obviously no case is the same, but there is, I suppose, a factual similarity between the facts of that case, the purported marriage in a mosque in London, in contrast with a purported marriage in an embassy in Kiev. And to go on with paragraph 69, the innovation, and one he was entitled to make in my submission, is this, that too is a determination of a question relating to the validity of the ceremony, which is binding, provided it is not obviously contrary to justice. The determination corresponds to our domestic concept of a non-qualifying ceremony, and so the appropriate remedy would be dismissal of the application for a nullity order. So he's there talking, I think, of a hypothetical. I've suggested that would be the position on a factual case like Akdar. He then gives another example at paragraph 70. If a ceremony was defective for want of compliance with necessary formalities, therefore the marriage was void, but the ceremony could later be ratified or validated by compliance, then such a determination should likewise be regarded as being a question relating to the validity of the ceremony, which under our rules of private international law is binding. That could be seen as commenting on the ramifications, and that's why I invite this court to look at that term introduced by Mr. Justice Mostyn in its widest sense. That binding decision is that the marriage is not non-existent, and therefore the appropriate remedy is a nullity order. And that's how he characterises my lord's case in Assad and Kurta.
So although he says that remedy is a matter for English law, in effect he's saying that English law is bound by foreign law, unless it's contrary to justice.
Well, I think he can't say the actual remedy. And indeed he doesn't, because that's going back to paragraph 68.
Well, he does. The appropriate remedy in 69 is nullity decree. The appropriate remedy in 68 is no remedy.
Well, that's his view of how English law would then treat. That's how I read those two conclusions. That's how he considered English court would treat the evidence of how the overseas, the foreign jurisdiction, would treat that ceremony. My lord, I accept that he perhaps elevates the view taken by the overseas court to being presumptively dispositive of the issue. But that's where I think he comes to building on my lord's test at paragraph 71. Mindful, as Mr. Justice Mostyn is, of questions of comity. And also, as I'll come on later in the judgment, he had the distinct advantage in this case of having very clear and very powerful and very decisive expert evidence that he was entitled to accept. My lord, the first two parts of the test that my lord Mr. Justice Moylan then found myself and Curter are set out at 71. We would have no particular difficulty with that, as indeed Mr. Justice Mostyn didn't. He simply purported to build on that test. Little c in my lord's test sets out what it is for the English court to decide, namely what the remedy should be under English law, if any. That does not, in my submission, exclude consideration of the wider question of ramifications, not only of what the remedy might be under the foreign law, but also, as I submitted before the adjournment, the other consequences, whether it be immigration, whether it be domicile, or whatever, of the ceremony being found to be either invalid and giving no ramifications or remedies on the one hand, and then a ceremony which might on the other. I know my learned friend has proposed a test to this court. We would not seek to reinvent the wheel, and we'd respectfully suggest that this court can start with the test at paragraph 71. But perhaps add to it an emphasis that each case must depend on all the circumstances pertinent to that case, which will include, in particular, and we have no difficulty with the cause or nature, or indeed the reason of for the invalidity. And this is, sorry, should be made clear, this is when determining the line between invalid marriages which can be and cannot be the subject to a nullity order. If in any given case, which as you know we submit this isn't, in any given case the English court has to draw that line. Plainly the facts of the ceremony are an important consideration. We would suggest that it's not so much a question of the parties' bona fides, but the parties' intentions as to what they thought the ceremony would do, and perhaps more generally, where they thought their relationship was going in terms of, even if this ceremony wasn't intended, given ceremony wasn't intended to be a marriage ceremony, whether they wanted to be married, particularly have in mind the South African case where there was evidence that although that ceremony wasn't intended to be valid, nonetheless they still intended to be married. The other important elements are those two introduced by Mr. Justice Mostyn. The ramifications under the law of the foreign state as to whether a line is drawn between those invalid marriages which can be or cannot be subject to a nullity order, and if so, how? And I repeat that this is not simply a question of narrow legal remedies in any action in England, but the wider question of ramifications. And then we do respectfully adopt Mr. Justice Mostyn's catch-all, unless it's contrary to justice. So there is a consideration of the justice of any particular case, which shouldn't be a difficult decision in most cases, even in those rare cases where there is the need to draw the line between those invalid marriages that can and cannot be subject to a nullity order. And in our submission, that is essentially the test that Mr. Justice Mostyn applied in this case. And I'll come on to where he deals with this case in a moment, but can I return then to the judgment? I've already made my submissions about Mr. Justice Bodie's case, the South African case. Our reading of paragraph 77 is where he uses quite strong language, perhaps not for this learned judge, but where he talks in terms of the duty of the English court to give effect to the foreign law, and the actual decision was completely at variance with the foreign law and made a mockery of the duty to recognise its disposition. This is paragraph 77. We would submit that he's there referring to that decision and that decision only, rather than to what he thought would be the appropriate test. And as he made clear in 79, the test that he applies is ancillary finding is binding unless contrary to justice. And what he means by that is clear from the second part of paragraph 70, or the second sentence of paragraph 78. But the authorities which I have cited above show with striking clarity that a degree of nullity in this jurisdiction is no more than a declaration that there is and never was a marriage between the parties. Therefore, the declaration made by Mr. Justice Bodie that its inception was a void, that at its inception this was a void marriage, which is prohibited by Section 58 of the Family Law Act. Then applying this ancillary finding is binding unless contrary to justice test. And he goes through his views of each of those cases, which I've already done. My Lord's dealing with this particular case. He makes the following findings about Ukrainian law. They're, of course, findings of fact, and in my submission, he's entitled to make these findings without, unless they're shown to be findings he's not entitled to make, this court should respect. I don't think there's any serious challenge to these findings. They're pretty self-explanatory that my lords know. I should draw attention to little 3. In order to validly marry, the parties needed to register their marriage officially. Registration means the actual formation of the marriage in what we would call a registry office, core requirements, etc. Nothing particularly unusual there. The parties never did this. Little 4, no doubt the parties, the marriage of the parties in the Iranian embassy is invalid. He then refers to some of the detail in the expert report. I don't need to draw attention to the detail, but just to observe how detailed the evidence Mr. Justice Mostyn received from the expert was. Paragraph 81 comes to his conclusion on that evidence. under its proper law, the 1997 marriage in the Iranian embassy is invalid ab initio, incapable of being later ratified. When choosing between the alternative of a void and voidable marriage, so he's making that distinction there. It's plainly void, and in my submission, he must be right about that. He then goes to the next question about what primary or consequential matrimonial relief, if any, and the answer is absolutely none at all. He distinguishes the facts of this case with my Lord's case in Assad and Kurta. 83, the marriage ceremony, as often these types of ceremonies are, had the capability of being valid if a different counterfactual is put in place, such as both of them being Iranian citizens. But the reality is that they weren't. Even if they relied on the marriage, and indeed relied on the status of the marriage for my client's entry into this country, makes no difference. That's one of the ramifications, I would suggest. While Ukrainian law doesn't share English law's use of the concept of a non-marriage, and this is an important finding, the single joint expert is equally clear that the ceremony in the Iranian embassy gave no rights to either party to seek anything. And that's the importance of the ramifications. And just to make my point, paragraph 84, Mr. Justice Mostyn, this is the key aspect of the expert evidence, in my opinion. In contrast to other cases where the evidence is ambiguous, this case could not be clearer.
Do you happen to know what Article 74 of the Family Code of Ukraine provides?
I think it's somewhere in the expert report.
Was it? Is it?
If it helps, page 80 at the top.
80?
80 in the core bundle, you'll see little Roman 9. That top of the page we're just looking at, it does describe from 2002, you can see on the third line.
Thank you.
I think we've got
somewhere, I don't think in the bundle, we've got it somewhere.
Yeah. Let me just find it.
Because what I was looking at is paragraph 17 on page 114. This is just a matter of interest.
Sorry,
Page 114, paragraph 17. I'm just turning over in my mind the application of this ramifications test. There it says that the court may recognise the existence of the in-fact marriage relations cohabitation between them during a certain period of time, as well as recognise a property acquired by them, and divide such property between them based on the legal rules applicable to the division of the joint common property of the spouses. So there's a remedy available based on the in-fact marriage relations, which is how, in the expert report, it's translated cohabitation.
Oh, yes.
So is that a ramification?
Yes.
It is.
Potential
So we should perhaps be applying that ramification.
Well, but it's based on 114. It's based on the hypothesis or the counterfactual that had the parties thereafter lived in Ukraine.
So why, to pick up Mr. Lewis's point, are we applying Ukrainian law as to remedies when the parties have lived in this country for many years?
It goes to the validity. It's questions of what. It goes to the validity rather than the actual remedy. That's my point. And in assessing the validity under the foreign law, Mr. Justice Mostyn had evidence of what would, in a counterfactual, in a hypothetical situation, be available. My lord, it goes on in other paragraphs to deal with the other ramifications based on the couple continuing to cohabit, which I can just bear with me one moment, I'll find the paragraphs. Well, the paragraphs, so page is 114. Paragraph 15. I think that was a similar point, actually. It's where it comes in the first letter of instruction. Yes. And over the page as well, paragraph 18.
It's an interesting expression, in fact, marriage
Yes.
relations. I hope we're not being asked to interpret what that means.
Clarification.
Well, it seems to be as if man and wife in the same, going back to our family law.
That's a bit to say. Yeah. Yes.
And Mr. Justice Mostyn himself deals with this in this section of his judgment. In fact, in the subparagraph 10 above, actually, which I've rather quickly skipped over. That's his long paragraph 80.
Well, it only has 9 subparagraphs.
Sorry,
Yes.
I'm misreading my Roman numerals.
Yes, that's the one Mr. paragraph Mr. Lewis drew our attention to, is
Yes.
setting out the effect of Article 74.
Yes.
So I think I was just coming to the close of the judgment and therefore my submissions. Paragraph 84, the key aspect of the expert evidence is that no rights at all derived from the fact of the ceremony. No ramifications, no rights, no consequences. And he marks how clear and unambiguous the expert evidence is. And then at 85, this evidence as to the ramifications of the invalidity of this ceremony is clear. And that's on the question of, as Mr. Lewis thought when presenting his question on whether the invalid ceremony does or does not give rise to the right of nullity. Where Mr. Justice Mostyn is clear as to the ramifications of the invalidity, and not only is he clear, but he finds presumptively binding on me. My Lord, in any given case, there is inevitably going to be a feature that is magnetic, has a particular spotlight. There may be other cases where there are other facts that don't mean that the finding of the foreign law is going to be so important. But whether or not this court accepts that there is some sort of presumption, it is our submission that the ramifications, in the sense that I've been using them, are going to be an important factor.
But, and I'm sorry to interrupt you again, Mr. Haynes, but isn't the absence under the foreign law of any form of relief or remedy in itself a ramification?
Yeah, I can't dispute that. Which is where then, as in the next sentence, the prism of justice comes in the hot air balloon case. It was plainly unjust because the ramifications were so dire for the wife, particularly on the findings that Mr. Justice Holroyde made. and then I'm going back to where I started my submissions at paragraph 85. Whether this court considers that the English court has a duty to respect all matters of the foreign court or the foreign legal system is a perplexing question. But in my submission, if one goes back to section 14 and interpret that section in the light of all sorts of observations about comity, respect for international legal systems, particularly where the English court does not have to rely on the old, perhaps slightly archaic, but still valid principle that we have to assume that other law is the same as ours unless the contrary is shown. Mr. Justice Mostyn didn't have to concern himself about that because the expert evidence was so strong, so clear. So to answer my learned friend's questions, he applied the right test and got to the right answer. If he had applied a slightly different test, perhaps not elevating foreign court's view on ramifications as presumptive, nonetheless, he was entitled to find that the ceremony in Ukraine did not give rise to a right of nullity for either party. And if that's right, there's no difficulty at all with construing the 1996 Act, because neither of these parties was even party to quote, inverted commas, void, inverted commas, marriage. But just to revert to finish, it's our primary case that Mr. Justice Mostyn didn't have to burden himself with this analysis for reasons that I developed before the adjournment.
Yes.
Unless I can assist further.
Oh.
Thank you. Those are my submissions.
No. Thank you very much, Mr. Hames.
My Lords, if I may, 4 very, very quick things just to reply.
Well, take them slowly if you wish.
Number 1, there was the suggestion, I think this is a factual issue, maybe that the issue of the status of the marriage hadn't been raised by my client until after or the very back end of the decision.
I don't think that matters.
But it's just...
That's,
well,
on the facts, you're going to say he raised it earlier.
Well, it's his skeleton argument before the trial in front of Recorder Allen is in there, and it's clearly set out in there. And actually, as it happens, paragraph 6 and 7 of the first judgment of Mr. Recorder Allen deals with that point.
Which paragraph in the skeleton?
I will tell you. So it's in the skeleton stage of the 3rd of May 2022, and he deals with it. Find it. This is taking quite a long time, actually. Starts at page 147 of the core bundle.
Yes.
And then it's paragraph 6 and 7 of the first judgment of Mr. Recorder Allen. And in fact, the second judgment of Mr. Recorder Allen deals with the concerns that he may have made a mistake when he was dealing with it in his first judgment. So it's a small little point, but it's just worth correcting. Second is suggested that this question of, in relation to Reneville, when my friend was speaking about this proposition that if you think through de Reneville, it's possible just to simply to walk away from a void marriage. I don't need to take Lordship through it particularly, but it's worth noting from the Law Commission report, which is in the bundle, a discussion at part 6.7, which we will find at internal page 51 of the document. And when I was making my submission this morning, I touched on the effect of remarriage, even if that marriage is void. Here, it seems to have been a specific recommendation from the Law Commission, which found its way through into the Act, that remarriage bar shouldn't apply where the parties had first merely been cohabiting. And the reasons we see 6 lines down, there's a semicolon. There are serious objections to introducing a similar bar for former cohabitants. The main difficulty, there's no clear cut-off point when it ends, in the same way that the decree absolute terminates a marriage. And here, most people who divorce have the benefit of legal advice in respect of ancillary matters and will either apply for the benefit of transfer of tenancy or under the 83 Act. No similar trigger to prompt cohabitants to make an application. So, I would submit it's not too much of a stretch to read into that. But what matters, what they thought mattered, was whether parties considered that they were in a marriage. Because if you consider that you are in a marriage, you are more likely to go off and get legal advice than if you consider that you are not and that you are free to leave, as it were, at any time.
Times have changed.
Quite, but that was the thinking. This is a report I think is in 1992, May 92. So change, but perhaps not as well. I won't pass comment on that. Third, my Lord Justice Moylan, during the course of discussion this afternoon, referred to the in fact relationship. I suspect that's in much the same way as certainly Australia and New Zealand refer to a de facto relationship. I think that's what it's had in mind. But it's worth just looking at page 115 of the core bundle, because it's actually even worse for my client.
Sorry,
115 of the core bundle. So, my Lord referred to the previous page at 114, paragraph 17, saying, again I'm paraphrasing, if there were an de facto marriage, there will be a claim. Over the page 18, however, the initial starting point of such in fact marriage relations, brackets cohabitation, between appellant and respondent may not be established earlier than 2002 as provided for in paragraph 16.
that was a change of the law.
So exactly. So this marriage took place in 1997 under the 1969 Soviet Family Code. The Family Code was amended in 2002 to bring in de facto certain, I don't mean this pejoratively, certain basic rights for de facto couples that didn't exist to others. But that came in. So these two parties, had they still been living in Ukraine, wouldn't even have had the advantage of those rights when they separated. That was the third point. The final point...
Sorry.
Forgive me.
Go on.
You're the same point. Yeah.
I think it means that you can't claim to have that relationship from earlier than 2002. Yeah. That's how I read it.
That's how I read it. It would be
I take that. I don't think an enormous amount turns on it, but it was just at 18. The initial starting point of such in fact relations may not be established earlier than 2002.
Yeah. So if you're in a long-standing relationship that carries on until 2020, say, you can't say it started before 2002, even though you were together for 10 years before.
As I said, I don't know much. I seem to recall, but not much. It's not important enough a point for me to spend time looking at it, but it's just I flagged that. The final point was in relation to this unless contrary to justice test, which we see at paragraph 73. And I just wonder whether it is worth highlighting a difference between the ability to bring a claim and the consequences or the outcome of what that claim might be if you brought it. Because one can imagine a scenario in which foreign law gave a right to make an application following a void marriage, the result of which was an outcome that instinctively we might be uncomfortable. And if that analysis is right, where we get to is a position where potentially the recognition of the grant of an entitlement to a nullity decree depends on who out of these two parties is bringing the application. Because there is a risk that if, for example, a wife, say, were to bring an application, the result of which would be something that we'd be instinctively comfortable with, it may well be that a nullity decree may be felt to be justified. But if the other part of the marriage were to bring an application which caused an outcome which this jurisdiction would not like, the effect of that, if Mr. Justice Mostyn's test is right, would be that whether or not a nullity decree is potentially justified could depend on who in that foreign jurisdiction brought the claim. That, in our submission, wouldn't be acceptable. Those are the 4 points of reply. Is there anything else I can help with?
Thank you very much. I think there is. Just in terms of where we go to from here, clearly we're going to reserve our judgments and we'll circulate drafts in the usual way, inviting you to spot the deliberate typographical errors that we will pepper them with, but nothing more substantial. But it's really where we go to from there, and just purely to look at options. If the appeal's allowed, then presumably it goes back to be reheard, or?
If the appeal, as I said before, if the appeal were to be allowed, my submission is that the order of Mr. Justice Mostyn is set aside, and because, as well as
so this is the wiping of the slate.
We wipe the slate clean.
Yes, that's your point there.
I'm not, and I think Mr. Hames takes the directly opposite view. If the appeal is to be allowed, the only question left is timing on his case.
Now that's if the appeal's dismissed.
Forgive me, if the appeal is dismissed, forgive me.
Yeah.
If the appeal is dismissed, the only question is
so
timing.
if the appeal's dismissed, then Mr. Hames says the only question is timing. Do you want to address us in relation to what you say should happen? In any event, thinking it through in my mind at least, there may be issues as to timing. I don't know whether Mr. Justice Mostyn heard submissions as to timing. He chose 2 months, but that was just him.
He chose 2 months because the reason he extended it.
I'm seeing Ms. Gideon shaking her head about.
No, it's right. It was because I was acting under the pro bono scheme, and because I had said to His Lordship that I might want to go and seek leading counsel before.
Right. So it wasn't.
He gave me a bit more time. That was the reason. Is that right? Yeah.
You've each hinted at there being factors each way that point towards a short time lag before the order bites on a new date, or a longer time lag. Certainly for my part, I'm loath to wait to give the reserve judgment and then adjourn that issue down to the lower court, and I'd rather that we fixed the date. But if we're doing that, we need to have at least some paper submissions about what the factors are that point to it being a longer or a shorter period.
I think realistically they only need to come from me, probably with Mr. Hames to reply.
Right.
Because I think we know what Mr. Hames is going to say if the appeal is dismissed. Let's just get on with it.
Yes, but Mr. Hames deliberately stopped him doing this, but he was indicating that there are pressing circumstances in the wife's home which indicate that sooner rather than later is not just, it would be nice to be sooner rather than later, there are pressing reasons why it should. Equally, I picked up from you that your client would clearly have difficulties moving straight out on a short notice date.
I would need to take some instructions.
Well, shall we leave it there? It's not a matter for today, but I think...
Well, perhaps when judgment's handed down in draft, depending on which way
yes, perhaps
it
we
falls,
deal with it on that basis.
We could, if you direct me, I can make submissions if necessary at that point.
Yes, because we may not, the parties need to know that we're looking at the options just so that we've got you here and we're doing that. It may not come to this, it may do.
Does your Lordship have any sense in the most general of ways about how long judgment's likely to take?
Yeah. It won't be before Christmas.
Right.
The generous vacation that His Majesty gives us is often used to produce judgment. So it'll probably be early in the next term, which doesn't start till the 11th of January.
All right.
So that's what we're looking at. But a wise, the person who would have to move from the current circumstances, if the appeal was dismissed, would be your client. So it'd be a wise man who prepared for the worst rather than hoped for the best.
Understood.
And that's again not indicating anything, but that's just
In the real world.
in the real world, that's a practical matter. And if we come to looking at a date and we find he hasn't done anything, then that's will be part of the factors in the case. I hope that's. I really have no idea what the outcomes are going to be, but I'm just canvassing practicalities.
No, it's occurred to us as well.
Yeah. Mr. Hames.
Can I just mention the eventuality of the appeal being allowed?
Yes.
It wouldn't necessarily follow that my client's application would be dismissed, although depending on how my laws allow
Let's see. I think the idea of circulating the draft with a substantive decision, and then there'll be room for submissions from you each about the ramifications of that decision. I'm extremely grateful. You're pro bono entirely on your side. I'm extremely grateful to you. And as you know, the Chief Justice has issued a diktat that junior counsel to be encouraged to take the lead in cases, perhaps not in the way that you have today, but you Mr. Lewis, should not be discouraged about appearing without a leader in these cases. Mr. Hames, very grateful to you and Ms. Gittins and your instructing solicitors. And as ever, whoever prepared the bundles, nothing went wrong with the bundles. They were all exactly as they should be. Thank you all very much.
Thank you.
Right.